Hello, everyone. Welcome back to our channel. My name is Rabab. I am a family law lawyer at AP Lawyers, and today we are going to be talking about mediations. What are mediations? Okay, so mediation is a way for you to resolve your legal matter, specifically your family law matter, because that's what we're talking about right now. Obviously, you can use it in other areas of law, but I'm speaking specifically about family law. So, usually, what happens in a mediation is that you get a senior lawyer who you've hired to help you mediate your matter. So it's pretty much self-explanatory. So they come and they're like, okay, so what are the issues? Party A, party B, what issues are we looking at? What issues are we talking about? You prepare briefs, they read the briefs, and they come and basically try to move the parties towards settlement as much as possible. Now, with mediation, if, for example, you are in a situation where, let's say you figured out all the child stuff. So you have both determined that, okay, the children are going to live primarily with person A, and person B will have the children, every other weekend and one time, during the week, let's say Wednesdays or whatever. And we figured out child support, we figured out spousal support, but we're unable to figure out equalization. You can decide to get a mediator just for that one issue of equalization while you figure out the other issues. If you're unable to figure out all your issues, obviously you can get a mediator to help you with the other issues. Now, a mediator usually is a senior family law lawyer who has obviously a lot of experience dealing with family law files and family law matters. So they're usually able to give you certain creative ideas on how we can reach a middle point. So, for example, if it's a situation where the parties are disagreeing on, for example, being like a liaison, like a medical liaison for the child when they both have, shared decision-making responsibility. It could be a situation where somebody suggests that, oh, instead of one person being the one to communicate directly, they do it through like a joint email so that if in that situation, if one person is contacting a doctor or a dentist or the school or whatever through that email, the other parent has access to that email and can easily go read those emails. So they're kept in the loop of what's happening instead of, having to forward those emails to another person. Obviously, that's just one example. But with mediation, I think mediation can be a very good idea because it's much quicker than it would be in court. If you're going through the court system, first you have to bring an application. The other party has 30 days to respond, and then after their response, you have 10 days to file a reply, and then you can get a case conference. At a case conference, you get in front of a judge, and the judge is trying to move the parties towards settlement as much as possible. If you're unable to resolve it after a case conference, then you go to a settlement conference, which is kind of similar to a case conference, but the matter is just gone a bit further. And the judge is like, okay, so guys, where are we now? Have we been able to reach an agreement on any of the issues? If we're unable to figure out at a settlement conference, then we go to a trial management conference, which again is like, guys, okay, we're nearing the end of our rope here. If we don't figure it out at the trial management conference, then it goes to trial. Most matters do not go to trial. Most family law matters, I apologize, do not go to trial. They settle sometime before that. And also, just because of the amount of backlog we have currently, it's taken a little bit of time before matters can be heard in court. Mediation is much quicker. So if for example, if you reach out to a court and they're giving you a date, right now we're in August. If you reach out to the court and they're giving you a date for January, February, if you speak to a mediator, you could get a mediation date in September. You know what I mean? So it's much quicker. It's cheaper in the long run because with all these conferences that you're attending, you're paying your lawyer to attend, you're paying your lawyer to draft materials, and you're not necessarily getting a decision at that point because you're in front of a conference judge. If obviously you bring a motion, if you lose the motion, you're potentially paying costs from the other person. If you win the motion, you're potentially getting costs from the other person. But again, it's not usually all your costs that you recoup. It's just part of it. And then if it goes to trial, obviously all these monies that you spend on the file, all of that comes into question. When for mediation, it's just one session usually, unless it's a more complicated file where you're doing a bunch of sessions for mediation. Either way, in the long run, mediation is usually cheaper. And then you can also attend mediation with or without counsel. Obviously, we would always recommend that you attend things like this with counsel because sometimes you might be opening yourself up to certain things and you don't understand the legal ramifications of it. So independent legal advice, incredibly important. Always get independent legal advice before whether you're going to court or mediation, but specifically mediation because that's what we're talking about here. What do you need to prepare to go for mediation? It would depend on what your matter is about. So if we're talking financial, we're going to talk about, you're going to need tax documents, you're going to need bank statements, credit card statements, you're going to need line of credit statements. We might need to get valuations of whatever properties you own, whether it's the matrimonial property, if there's other investment properties, if we're talking about properties abroad, or maybe not necessarily even abroad, but like out of province. So if we're talking about, you owning a property in like Alberta, for example, if you own a property in Jamaica, if you own a property in Zimbabwe, these need to be valued because these are coming into consideration for the net family property statement. You're also likely going to need to prepare a brief. This would give the mediator a snapshot of kind of what's happening in the matter. It would give them a breakdown of what your position is. Obviously, the other party would be doing a brief as well. So the mediator will be able to kind of see things from both sides of like, okay, so this is what party A is saying, this is what party B is saying. How can we meet in the middle? So if you have vehicles, if you have boats, if you have a yacht, all these things need to be valued. These are things that are going to come into consideration when determining the financial matter. If your issue is with regard to parenting, obviously we need to know exactly what your position is. Are you seeking sole decision-making responsibility or sole custody? Is it going to be joint? Why are you seeking what you're seeking? You know what I mean? If it's a situation where you're looking to change the child's school, why are you moving the child's school from where they are currently to another school? Are they currently in private school and you're trying to move them to public? Why? Or vice versa? So it's going to be a situation where a mediator is trying to see what makes the most sense and how we can move the parties towards settlement as much as possible. With the children also, is there like a relocation situation happening? Why are you trying to relocate? Why isn't, where you are ideal currently, And if you're the person who's opposing the relocation, why are you opposing the relocation? Obviously, you'd be thinking about how, it would affect you seeing your child and things like that. So these are all things that need to be prepared for when, you're doing a mediation. So it's similar in terms of like if you're going to courts, it's just that, like I said, it's quicker, it's cheaper in the long run. And you just have to do what makes sense for you. So I hope that kind of gives you a little bit of an idea of what mediations are like. And I also forgot to address if, for example, the mediation is unsuccessful and you're unable to reach an agreement, at that point, then you can decide to go to court, because at that point, you'd have tried mediation and like, let's say it didn't work for you. At that point, you could be like, okay, let's go to court. This is not working out. Maybe we need some judicial input. You could also decide to go to arbitration, where either you have that same person who acted as your mediator be an arbitrator, where they come and they're kind of the decision maker. They hear the matter and they're like, okay, at this point, this is the decision that would be made, because a mediator can't make a decision. A mediator can only guide you. An arbitrator can make the decision, and that decision will be binding. If you're using the same person who was the mediator as the arbitrator, they have an obligation to basically destroy their notes and whatever they've taken from the mediation and attack the arbitration with fresh eyes. But if you're a person who you prefer to get another person as an arbitrator, that's something that you could do as well. So that's another option for you if that's something you kind of want to look into, whether it's arbitration or if you're going to go just straight to court. So those are kind of your options with regard to that. I hope that kind of answers all your questions with regard to mediation. Please let us know if you have any more. Enjoy the rest of your day. Take care.